This is part 3 of property, beginning with future interest. A future interest is an interest in a presently existing property which may commence sometime in the future. Some language that may be repetitive. We have a reversion. A reversion is a future interest held by a grantor of a life estate that is not conveyed to a third party. So here you have 2A for life. So the grantor has a reversion because they didn't say 2A for life, then heirs. At the end of A's life, it will revert to the grantor. That's a reversion. It's a future interest held by the grantor of a life estate that is not conveyed to a third party. Interest in property reverts to the grantor. Possibility of reverter is a future interest automatically retained by the grantor of a fee simple determinable. And again, remember, a fee simple determinable is limited by specific durational language, so long as, while, during, until. Looking at the right of reentry, that's a future interest retained by a grantor of a fee simple subject to condition subsequent. And remember, those condition subsequent is limited in duration by specific conditional language, provided that, on the condition that, but if. Looking at remainders. Of note is that a remainder never follows a fee. So when discussing this, we think of life estates. When we discuss remainders, we think of life estates. So in the context of a life estate, a remainder is a future interest held by a grantee capable of becoming possessory upon the expiration of a prior possessory's estate of known fixed duration. It's a future interest held by grantee, that would be 2A for life, then C. So the future interest held by the grantee is C, capable of becoming possessory upon the expiration of a prior possessory estate. That's the life of A, of known fixed duration. Again, the measuring life of A. Now, the remainder can be either vested remainder or contingent remainder. Vested remainder is not subject to any conditions, has an ascertainable known grantee. These may be either vested subject to open or vested subject to complete. A vested subject to open is a vested remainder in a grantee where other grantees may become vested and share in the grant. An example would be a conveyance to children at the age of 18. At the grantor's death, one child is 20, the others are 12 and 15. Vested subject to open is other grantees may become vested. At that grantor's death, only the 20-year-old is vested, the 12 and 15-year-old are not, but if they make the age of 18, they will be, and then they will become vested. So that's vested subject to open. Under the vested subject to open, we apply the rule of convenience. This is where later born children do not count. Gestating children do. The class, which is the grantees, the class closes when any member of the class becomes vested. So above, the 20-year-old vests, so the class vests at the grantor's death because the 20-year-old's above 18, and therefore that entire class closes. If the grantor's wife goes and has another kid, that's irrelevant. Class has closed. If the grantor's wife is pregnant with the child, that child that is gestating will be considered part of the class, but that class will now be closed. Thus, vested subject to open, vested subject to complete is the occurrence of a condition subsequent will completely divest. So it's subject to complete divestiture of the remainder. An example would be to C if C has children. If not, then to D. If C has no children, then it goes to D. C is completely divested of the remainder. So those are vested remainders. We have contingent remainders. A contingent remainder is a remainder in an unascertainable grantee or subject to an express condition precedent to the grantee's taking. An example is 2B for life, then to C's heirs. Now if C is alive at the conveyance, C's heirs are not yet ascertainable. Majority of jurisdictions, this becomes a springing executory interest, which fills the gap in the estate. Going further with executory interest, and this is an exam note, I stated this a little earlier, any interest held by a third party, such as A to B for life, then to C, C is the third party. Any interest held by the third party that follows a fee is always an executory interest because a remainder never follows a fee. Again, that's just saying that remainders only follow life estates. Everything else that's in a third party is an executory interest. Here you have springing or shifting executory interests. These are future interests held by the third party. Again, C in that case. That is not a remainder, and this shifting or springing cuts prior estate short upon the occurrence of a specified condition. This is transferable. It's subject to the rules against perpetuity. Exciting. A shifting executory interest divests the grantee of interest and shifts the interest to another party on the happening of an occurrence. An example of a shifting executory interest is to B and heirs, but if C returns from Paris, then to C. Example of a springing executory, a springing executory interest fills a gap in possession, such as the example above, A to B for life, and 1 year after B's death, then to C. Then create a life estate for B, a reversion in A, and a springing in C. Transferability of remainders and executory interest. Vested remainders are fully transferable. Executory interest and contingent remainders are transferable while the grantor is alive, divisible, and descendable. And that completes part 3 of property.